I know that you guys have long days and you're ready to go to the party, and so am I. There are samosas being heated up, and that is what I look forward to this evening. So we will get this started. So for those of you who don't know where you're at, you are at CLCP, and this is the Criminal Records Expungement, CLE, and preparation for our December 12th expungement clinic. My name is Jamie Moore. I am the legal director here at CLCP, and I have the pleasure of teaching you what I know about criminal records expungement. So hopefully you'll leave here with a greater level of knowledge and understanding about this particular area of the law. So just a basic outline of what we're going to walk through. We're going to just look at what is and what's on the average criminal record, how to access a criminal record, an expungement versus a redaction. Some people don't understand the difference between the two. And technically, I should say expungement and redactions, because it's not like they stand opposed to each other. You can just get one or the other depending on your circumstance. And then the steps to get a record expunged. So before we jump a little further in, all of you guys will have what I call a cheat sheet at the top of your papers in your folder. Keep that with you. You may not remember everything that I go over here, but as long as you have that sheet handy, it'll refresh your memory, and it's a good guide when meeting with clients. So, criminal records. What can you find on a criminal records? We have a couple things that we're concerned with, a couple things that we can address through this particular seminar. First, everybody knows that you'll find a guilty or a guilty plea on a criminal record. These are charges where a defendant was found guilty or pled guilty, and therefore those things remain on the record unless they file for and are granted a pardon. What we're going to address here today are arrests and errors, things that are on a record that aren't guilty, everything other than. So as you can see, these are charges where a person was arrested, the charges remain on their record, and there is a disposition that is either not guilty, an acquittal, no process, dismissed, withdrawn or dismissed due to lack of evidence. Whatever other dispositions you may find in the column next to a person's charge that doesn't state that it's guilty. And also we have people who have come into our clinics who have had errors on their records. Particularly, there's one situation where we actually had a gentleman come in and somebody had been using his identity. And this person had been arrested multiple times under his name. And he had actually gone to the police department to let them know, like, this isn't him or this wasn't him, but the record was still listed under his name, so we had to go through the expungement process for him. He actually just had his petitions granted, thank God. So we're praying that now the next step is that once these petitions are granted and all the letters come back in, that he'll be able to find a new job, because he was terminated from his previous job because of the record that he had. Yes, so this is real, and this is one of the reasons why there's been such a great push towards getting people's records expunged as of late, and it's because there's a lot of access to criminal records. So one, you have these two, I would say, like, injustices that are playing against clients. You have the one injustice where a person is arrested, they're found not guilty, they are acquitted of whatever the charges might have been, or for whatever reason the charges are dropped. They're not convicted of anything, but yet this record still remains, and it's listed as if they are guilty. Because what's the difference? You look somebody up and they're guilty, you see the charges, and you look somebody up, if they're not guilty, you still see the charges, and the arrest is still lingering there following them. So that's one injustice. The other injustice is that not only does this record remain, but there's still access. There's a lot of access to the record, and that's where you have the issue of people either not being hired for jobs or being terminated from jobs unlawfully, but still being terminated from jobs. And I'm sure there's a lot of pretense that employers may use when they see that there's a person that has, an arrest record as long as my arm. And this is the reason why people need criminal records expungements. It should happen automatically one day. Prayerfully, it will happen automatically. There's legislation that's being pushed so that it ultimately will happen automatically. But for now, this is the process that our clients have to go through. So there's several different ways that a record can be accessed. The first way that we have listed up here is through AOPC, the Administrative Office of Pennsylvania Courts. And this is what we'll use during our clinics, and this is what a lot of attorneys use just to pull up a client's record and to see what has been there from their first arrest in 1907 to, their last arrest last year. You can find all of that information on AOPC. It's free, and anybody can access it. Employers can access it, family, friends can access it, neighbors can access it. If your dog is smart enough with a computer, your dog can access it as well. And all you really need is a person's name and date of birth, and you can pull up whatever's attached to them. So imagine having some arrest. You might even know that this is on your record, because a lot of people come in and they don't know until someone does a check and they're like, wait a minute, but that was a fight that happened in 1989 and I didn't serve any time, like I got arrested, but that was it. And they didn't know that there was still a record attached to them from that incident. Another way that people are able to access criminal records is through the state police system, And this, you need to pay a $10 application fee, but it's really easy. Once again, credit card, a person's date of birth, social security number, and you can, within 10 minutes, have someone's record pulled up. There are times where they may have to do a lengthier search if it comes up that this person might have been arrested in multiple locations. So under those situations, there's a record that'll be mailed to you, but either way, anybody can access it if they have your information. And we have consumer reporting agencies, which are a dime a dozen, and yet another way for employers and whoever else wants to access a person's record to get this information. The issue here is that not only does a person have access to your information, but a lot of times the information isn't reported correctly. So we had a client that came in one time, and he very well organized. He had a binder. And he came in and he was showing me all of the documents that were pulled from one of these agencies' background check systems. And there were charges that were misdemeanors that were listed as felonies. And I thought, no. But an employer doesn't know that. Like, an employer's not like, oh, wait a minute, that's really not this right here, and that's really not that right there. And they see all of these things listed, and then they come to a conclusion about the person who has interviewed or is interviewing for a particular job. Yes, ma'am.
So you're talking about the Consumer Reporting Agency mislabeling a conviction as a felony when it was really a misdemeanor.
Yes, ma'am. But one second. I'm sorry, Vicki. Because we're recording, I need to hold all questions to the end. Oh, I'm sorry. I didn't make that clear in the beginning. I am very sorry. And sorry, Scott and Pete. Yeah. So it was really funny when I looked up this particular site. Check someone's background in minutes, like literally. In a moment, you have what you think is a clear background check. And they're like, check your neighbor, check your friend. Like literally, they're running down all kinds of relationship types that you can just check on just because. So these are another reason why you should be aware. And of course, we have an FBI background check. And that's a little bit more detailed, and you have in your folder just the requirements for an FBI background check. Not many people are going to probably put in the time and energy to get this done, but yet and still, if they have the right information, the right access to you, a record can still be pulled. And if it's a record that has items that shouldn't be on there, it still has a negative impact on the client's life. So we have these two things that can be done to help clients clear up their records. We have an expungement and we also have redactions. Expungement is the best scenario. And that's when a client has been arrested and everything that they were arrested for was basically not guilty. So somebody was, picked up, charged with aggravated assault, simple assault, attempted homicide, and reckless endangerment of a minor. And everything listed, not guilty. No fines owed. This person is eligible for an expungement because there's nothing that they're guilty of. So there's no technical need to keep this particular arrest on record. That's what happens when a record can be expunged. A redaction is the next best option. And that's basically if you have all of those same charges, but the person was only found guilty for like simple assault and everything else is not guilty or everything else is no pros. In that situation, that person can have everything else that's not guilty or no pros removed off of their record or blacked out off of their record. The arrest still remains because you have a guilty attached to it. So there's a reason why the police department needs to keep that in their central repository. There's a reason why the FBI needs to keep the fingerprint card. There's a reason why the the Philadelphia Police Department needs to keep their records, and the courts need to keep their records because there's a guilty still on file. But everything else that's not guilty can come off of that person's record. So it's something. It's not everything, but at least it's something to help them move forward and get the things that don't belong there off of their record. So we went over these items, and I told you before, these are things that can be removed. And if you want to look up the statute where all of this comes from, all this material where you see a code, it's listed or it's found in your folder. So you can find the expungement regulations, you can find the 790 rules and the 490 rules in there, and both of those we'll go over a little later. But those basically apply to the format for filing your petitions for expungements. So one of the things that was listed that can be removed are basically when a person is placed in a diversionary program. So you may see a disposition that says ARD on a record. If someone is enrolled in ARD, which is an accelerated rehabilitative disposition, that person, once they fulfill the requirements, can have that removed off of their record. So a requirement could be attending 6 months worth of classes, paying $250 in fines, and maybe like community service. And once those requirements are fulfilled and they're signed off on, the person will receive an ARD letter. That letter will be attached to the petition, and those two things will be handed in and filed as one. And it should basically be no contest to the expungement petition that's been filed. And these are just a couple other diversionary programs that people can get enrolled in, or just an option if the DA presents it during a hearing or before a hearing, so that they don't end up with a guilty on their record. And all of these things can come off once the requirements are completed and the person files a petition for an expungement. Summary offenses, these are filed is very much like a 790, except for it's for summaries. So when filing your petitions, just make sure you have 490 everywhere. You may have seen 790. And there's a sample petition in there just so you can see what it looks like. So when you're looking over that, what it should say in all the spaces where there's 790 is 490. And the same thing will go when filing a redaction separate from an expungement. Wherever you see expungement, it should really list redaction. And they're sticklers about those particular phrases and numbers being on the petition, because then that lets the court know, or the motions unit know, where this particular petition should go and how it should be filed. So with summary offenses, one thing you need to make sure is that there are 5 years since the arrest, but also 5 years of no arrest after that arrest. So there may be a client that has summary offense from 1999, but they were picked up in 2012 for something very unrelated, a totally different, maybe even totally different summary offense. They need to be 5 years clear of arrest prior to filing that petition. So they would have to wait till 2017 before they can file the petition for the 1999 issue, because within the 5-year window, they haven't been 5 years clean of any arrests. So steps to expunge a record. It's pretty straightforward. Pull the record. Number one, you want to see it, you want to review it, but you also want to review it with your client. There are people that will come in and it's not their record. It's not their name, or you may pull something under their name and then find out that there's a totally different alias that they have an arrest under. So recently I had a client that came in and her name was like, I'll say Dana. And there was an arrest listed under Dana, but then talking to her, she said she got arrested a second time and they put her name as Darlene. And she kept telling them that her name wasn't Darlene, but they still had it listed as Darlene. And so when you pull up the second record, it wasn't an alias that she used. It was just that for whatever reason, the arresting officials decided that they weren't going to listen to her because she didn't really know what her name was. I said, your name's Darlene. So she ended up with this additional record. So it's really important to review their records with them to make sure what's on there belongs to them and that you're covering all aspects of their record. You can access their record through AOPC, but there are some clients that are going to require you to do an access and review check, and there should be a form in there for that as well. And actually the fee isn't $15, I'm sorry, it's actually $10 for the access and review background check. And there are certain counties outside of Philadelphia that actually require this with every expungement petition, but Philadelphia does not. And it could be because they just receive a lot of petitions. But yeah, it's not a requirement in Philadelphia, but sometimes it is beneficial to have it done in advance because there can be issues between the records that the courts have and the records that they have in the central repository. And when you have that issue come up and the courts have already erased their record and they still have a record on file at the central repository, it makes it difficult to get the ultimate record removed for your client. So sometimes you might want to look through, if it's a person that has a lot of arrests, it's just more beneficial to pay the $10 or have them pay the $10. It'll take a little bit of time. It could take up to 6 months to get the access and review report back, but it'll be worth it if their record is a little bit more convoluted and lengthy. So, as mentioned earlier, you want to look for convictions, you want to look for the grading of the convictions, and we'll kind of cover that a little bit more as we go forward. Look for whatever arrests are on there. Errors, costs, and fees. This is probably one of the more frustrating aspects of a client's record. You could have somebody that comes in, they are eligible to get a redaction, most cases, and you get down to the end, you're excited, they're excited, you get to the last page of their docket sheet and you see that they owe $2,000 in costs and fees. And your heart breaks for them because at this point in time, they don't have the money. If they had the money, they probably would have taken care of it already. But they can't get their record cleared unless this is already paid. So now you have this issue where they're stuck. Or there's a situation where somebody can get one arrest cleared through a redaction, but they can't get another one cleared because it's just all guilties. They owe $2,000 on the all guilty one. They owe $5, right, on the one that's mixed. Well, if they were to go down and pay the $5 will be split between the two. Yes. So you might get 5 cents on your $5 and then $4.95 on the arrest or the conviction where you owe the $2,000, and you continue to pay that until that gets paid off. So that's something to be very aware of when handling these clients. You always want to look at the docket sheet. The court summary is great. The court summary will tell you what they're eligible for. The docket sheet will tell you whether or not you have a green light or a red light based off of what they owe to the courts. So this is the AOPC website. This is where you'll go, where you'll find the docket sheets. I suggest that you look under the Court of Common Pleas at all times. You can find stuff under the municipal court, but the Court of Common Pleas is the umbrella. So all of the MC cases will be listed under the Court of Common Pleas umbrella, but the CP cases won't be listed under the municipal court umbrella. So whenever going, you can hit docket sheets and you'll have the option to choose which court you want to look at. Go to Court of Common Pleas, and that way you'll be able to find out as much information as possible about your client. So you want to look up by the participant's name and birth date. You can just look up by the name because sometimes there are issues with the birth date. There's times where the birth date's in one day off. I don't know why, it just happens. So, and the person knows their birthday. So if they're telling you they're born on March 1st, believe them. They really are born on March 1st, 1968. It may be listed on March 2nd, 1969. You believe them that they know what they're talking about. It's just that for whatever reason, somebody thought they knew better than I know what day you were born on. So be mindful of that. And, when you're looking up their record, especially, and there are people, a lot of our clients come in, they're very honest about what's taking place. And they may say, when you look up, say, you don't have a record. And they say, yes, I do. No, but really, I looked up your information and you don't have a record. Yes, I definitely have a record. And then you'll go and you'll look, and you may have to adjust some dates or adjust the date that is listed for when the complaint might have been filed. So you might want to start out with, if you don't have a birth date that you can work with, you might want to select like January 1st, 1901 to December 1st, 2015, and see what comes up for that particular name. It all differs, based off of how common the name is. So you might not want to do it for Joseph Smith. But if you're looking for Zechariah, McDonald, that might be a name that isn't as common, so you could find stuff that's specifically for this particular client. A name and a last name listed. This won't go away because this is the perfect file. So here goes a good way to look up someone's record. And you'll see here, you put in the name, the last name, the county. You don't have to select the county. You can select any of these options here. And then you'll have, here goes the CP. This would not have come up if you looked under MC. Here goes the CP, and the criminal record will show up. And then you click on it, and you'll see, I'll point here. But this little magnifying glass here, you'll have the two options. It'll say court summary, or it'll say docket sheet. Select the court summary just for a quick overview, and then once you get a quick overview, then you can go to the docket sheet and get a more detailed, there we go, docket sheet court summary. So here is a record that should be eligible for expungement, would definitely be eligible for expungement in Philadelphia County. We have 2 not guilties listed on this particular record. I want to ask a question, but I can't. we have 2 not guilties on this particular record, and then we have them listed as summary offenses. So summary offenses are filed under the 490 petition, not the 790. If it's filed under 790, I just had this happen this week, it will get rejected and you will have to refile it under a 490. So be mindful that it has to be filed under the 490. So here goes a couple other records just to kind of get a better idea of what you'll find on your court summary. You'll see here we have a couple of dismissed. This person who has all these items that are dismissed are eligible for a full-on expungement because there's nothing there that's listed as guilty. You'll see the fields that are blacked out here, but those are very important fields in filling in your petition. And after the fact, we can kind of take questions and discuss what needs to go into the petition. Dismiss lack of evidence. It's dismissed. It's lack of evidence. If enough time has lapsed, it shouldn't be an issue with getting this expunged. I would say you want to be mindful of the timing of filing for the expungements. So we've had clients that have come in maybe a couple of months after they've been found not guilty of the charges that have been dropped or dismissed. And I always advise them to wait at least a year because the DA is not going to go down without a fight. And honestly, it's not enough time in 3 months to determine whether or not this is something that may happen again or whether or not it's a wise decision for them to just allow this record to be cleared off. So clients come in, be patient, wait a year, and I'm pretty certain that the PD's office also requires that clients wait a year before filing for an expungement or a redaction. Here we have 2 people or a person who has waited longer than a year, way longer than a year, about 7 years. And here you have a mixed bag. And there are a couple things going on here that I want to go over. So you see that there are the charges that have been held for court, and then you have the charges that are either found guilty or no prost because they have a guilty plea. A lot of times you'll see on people's records where the charge will be listed in 2 places. The first place will be after they've come in, they have been processed, the judge has determined that, these are charges that they're basically grounds to move forward and having this heard at, during a full-on trial. Those charges will be listed as held for court. A lot of times you need to make sure that you're matching up the information so that you're not filing a petition on something that's held for court when you may look at it later on and it's all guilty because it's all from that exact same arrest. So you have to be mindful of these details. Here for the guilty plea and the no prost, you'll have a situation where somebody may have pled guilty, and this is a good guilty plea, if there could be a good guilty plea. This is a good one, at least for expungement purposes. This person pled guilty to criminal conspiracy, but the bigger crimes or the more serious crimes were no prost. This can help them. This can help the person. Aggravated assault, murder of the first degree are coming off of their record, and all they're left with is criminal conspiracy, as opposed to pleading guilty to aggravated assault. And murder in the first degree is still good to come off your record, but still pleading guilty to aggravated assault and only having criminal conspiracy coming off of your record, it really doesn't help much. Even though we try to help our clients as much as possible in this particular area, it doesn't help much. If someone wants to do it just because they just want to offer their record, we'll do it. But we have to explain to them that there's nothing we can do about a guilty on your aggravated assault. There's nothing you can do about a guilty on your murder charge. It's just there. But this is a redaction. So this is a person, if they don't owe fines, they are free and clear to get this redacted off of their record. This is a mixed bag situation, but it's a good one because there's no guilties on here. All not guilties, all no pros. Very lengthy, very, very lengthy. But look at all that good help that somebody can get. All that lengthiness can be white as snow. How about that? So just be, mindful of the different options, the different types of cases that will come before you. And it's another one. You have one on here where it would possibly be a redaction, but everything else would end up being an expungement. And then the last charge is they're just stuck because it's a guilty plea. And these are all just other options. So, steps to getting the record expunged. Petitions. We already went over sitting down with the client, reviewing their record. You know the difference between $790 and $490. Filing fees. $15 per petition. And $15 doesn't seem like much. $15 per expungement petition, and $12.50 per redaction petition. Doesn't seem like much, but it can add up. I have a client that I really want to say, sir, I know you can't afford this. Please just let me know that you can't afford this and we can take the proper steps to make sure your petitions get filed. But he is determined to get this money together to file his petitions, and it's $87.50 for his expungement and redaction petitions to be filed. Per petition and multiple arrests can become very expensive for your clients very quickly. A lot of clients do qualify for IFP status in Philadelphia. It's different for the counties outside of the city, and the cost is actually a little bit more expensive for the counties outside of Philadelphia. I want to say in Montgomery County, it's probably the same in Delaware County. It's like $26.50 just to initially file, and then you have to pay an additional $12.50 for each agency that you want to receive the order. So yes, it's very expensive. So Philadelphia County is flat rate per petition, no extra cost after you file. This is what it is. In Philadelphia County, you file electronically. So this is the website you can go to. It's very straightforward. Outside of Philadelphia County, you don't file electronically. They're a little bit far behind us. So you actually you can mail it in, and sometimes they're not as gracious with not having all I's dotted and T's crossed when mailing in your petition. So you want to be very thorough and going through the process when filing outside of Philadelphia County. If you don't have an I dotted in Philadelphia County, they reject it online. You see it, you fix it at your computer, you turn it back in, and you can have a 15-minute turnaround in fixing your petition. If you need to fix a petition outside of Philadelphia County, it could be a several day, week turnaround between the time that you mail it off, they receive it, they reject it for whatever reason, mail it back to you, you fix it, then mail it back to them, they receive it. So just keep that in mind when filing petitions outside of Philadelphia County. Philadelphia County also has the option to file your petitions as a single petition, or if you're filing a bunch of them, you can file them in a batch. It's whatever your preference is. I prefer to file them just a single petition. It just makes it easier for me to track and to remember what has been filed. Some people prefer to file them all as a batch and just wait to see what comes in and what's been accepted and if anything's been rejected. Right now in Philadelphia County, and I apologize, but most of our work is here in the city, it's about 3 to 4 month wait between the date that you file to your hearing date. So we just filed some petitions last week, and the hearing's on March 3rd. So just keep that in mind. Just make sure you let your clients know that it's not a 30-day turnaround. At one point in time, it was. But this year, I guess, with shifting and certain things changing and how the courts are structured, we now have a slightly longer wait. So on the hearing date here, all the hearings are held in courtroom 1104. So what ultimately happens is that you go in with your client. Please advise your client to actually be there. Some clients don't have to be there. Some clients, your record's so straightforward, you really don't need to be there. For those clients who have a little bit of extraness going on, they need to have their extra selves present. So that way they can be a part of the process. So your hearing date, most hearings are held at 9 a.m. in courtroom 1104. And what initially happens is that you go in and there is more so like a court officer that's there and just statusing each of the petitions. And the DA will determine whether or not they want to oppose it. If they don't oppose it, petition is granted. In that moment, you're good, you go home. If they do oppose it, you go to a second hearing in courtroom 805. And this is where your client needs to be prepared to present testimony. And if your client has a lot going on, they really need to have some letters of like recommendation, some type of documentation that they're doing something good with their lives now. Maybe even a good character witness or a character witness letter, so that just in case, because it all depends on what kind of DA you get. You might get in the 805 and the DA say, you know what, I was just picking with you. You can go ahead. But you might get in there and it could be somebody that's very eager and just really pushing for whatever reason. So you need to be prepared for that particular scenario. And sometimes it can get kind of messy. I've been present where the DA wanted to read out, every piece of the initial criminal complaint. And I was like, why? Like, all of that is totally in the past, and what he was guilty of or what he pled guilty to, everything else was no pros. Why are we going here? But your client needs to be prepared for that to take place and for some things from their past to be rehashed in detail before the judge, because ultimately the DA is trying to win as well as you are trying to win for your clients. But one thing that should be kept in mind is that there is a high burden that rests upon the DA to be able to maintain these records. So they need to be able to present specific compelling evidence to justify the retention of the criminal record. Not just, we want this, we need to have this, but it really has to be like spot on specific. These are the reasons why. This is, this person has been arrested 25 times for this same exact crime. And, it's not that they've been found not guilty. It's just that witnesses aren't showing up. So that's the reason why we're having to throw out these, charges. But we feel like it's necessary for us to keep this record for these particular reasons, because there's a likelihood that this person has this MO and will continue to do this throughout their years. Long and short, they have to put up a really good argument. And so I have a list of case law that was created by Mike Hollander. We want to give a shout out to him, because he and Michael Lee, who started an organization called CREP, Hollander is now with CLS, and Michael Lee, I can't remember the name of his organization. They originally trained us on doing expungements. So there's a nice case law cheat sheet in your folder with the different cases that you can look to in defending your client's expungement petition. Yay, petition granted. What do we do now? Not a lot in Philadelphia County, thankfully, and honestly, not a lot in Montgomery County as well. Before, you used to have to then take a copy of the order and then mail it off to the different agencies. But now the courts are very gracious that they do it for you. In Montgomery, Delaware County, all the other counties outside of Philadelphia, you have to send an envelope with postage. So they're really literally just mailing it for you. You have to send an envelope. You paid them all this money for all this work, and you still have to send an envelope with postage so that you can receive the letters once they're sent out. So you can receive a copy of the confirmation letters that everything has been removed off of the record. In Philadelphia County, once you submit your petition, you get your order in the mail. You wait to get your letter from the Philadelphia Police Department, and there's a backlog with them as well. I think they're finally up to maybe August in the petitions, like handling the petitions that they've received, or the orders they received. So there's a backlog there. There's not a backlog with the Pennsylvania State Police Department. And with the FBI, it's basically a waiting game. You have to wait 6 months before you give anybody the okay, because they're the FBI. They don't have to rush for us. So wait 6 months and say a prayer that they followed through with the order that was sent to them. And I think this might be, yes, thank you, Jesus. So I promised that I would get done within 45 minutes so that I could take some questions from you guys, and then you guys can go on to enjoy the festivities that are going on across the hall. So I want to keep to my promise. Vicky, yes.
Oh boy, this is one of those times where you can't remember what your question was.
So you were asking about the consumer reporting agencies not having the information on their systems correctly.
Yeah, that's worth money.
It is, but that's your wheelhouse.
Well, it could be anybody's.
That is true. That is true.
Remember you had wheelhouse?
Yeah.
I've never heard that before. Wheelhouse. I'm going to use that word a lot. But yeah, that could be everybody's wheelhouse.
Yeah, I know. Wait, Chelsea and then Terry. Good.
Do you all ever done pardons? Is that?
So we don't do pardons, but we do work with the gentleman, Wayne Jacobs, who runs the Pardon Me clinics. And we actually held like an expungement clinic over there with him. And he's very much into empowering the person to do it themselves. So what he would like from us is, at some point, if we can galvanize enough law students, have the law students to review the pardons applications for the men and women that are coming over to his office. Yeah.
That was my other question about pardons. Okay, and the other day, I have this case going on in Northampton County where the woman was convicted of murder, but she says the person is still alive. And so I was thinking, oh, maybe this would be a good case for a pardon, because if the person didn't die, it can be murder.
True.
And so, like a soap opera or something. I don't know if it's true or just a crazy story. I don't know. But I did look on the website, and there were statistics, and just about in every governor administration, there's several hundred pardons per year that are granted.
Yes.
People are getting pardoned. It's happening.
A lot of times, though, those are for lesser offenses. So
Right.
people are getting pardoned for like shoplifting, maybe like disorderly conduct.
Or
It's-
maybe something where it's proven that they couldn't have committed the crime, and then everybody looks at the file and they're like, why did this person plead guilty, or how could they have been convicted? And so they just decide to pardon the person, maybe. Who knows?
Who knows? You're right. The Pardons Board does. The Pardons Board. Maybe one day we will know.
Or we can sit in for free, you know. I mean, anybody can go to these pardons hearings, right?
You could go to the hearings. You don't know what's in the mind of the board. But yeah, you can go to the hearings. Let me get Terry real quick.
The probation without a verdict, what is that exactly?
Without a probation, without a version.
Like probation without a verdict, so like if they put you in probation but you didn't like plead guilty or
Yeah, so I had a situation that came in like that, right? So that's kind of like guilty.
so it's like a guilty, so they say guilty but they're on probation, and if they do the things then they're okay, and like and that is expungable?
Did I have that on my diversionaries?
I felt like it was.
It was?
As long as you complete the probation,
Yeah.
it's also like an ARD, and you can, it's
Yeah.
not a conviction of one.
Yeah.
Okay.
Yeah, no, those are quotations. So we haven't had the probation without verdict happen here. I did have a situation where it wasn't probation without verdict. It was, were they given probation? I don't know what the gentleman was given, but basically he was given a disposition without it stating that he was guilty. But because he was given the disposition, he was it probation? I don't think it wasn't able to come off his record. It wasn't a guilty and it wasn't a not guilty, but it was something along the lines where it was almost like pleading the fifth. But that's what it felt like when I was going over it. Like it felt like pleading the fifth. But yeah, so we haven't had the probation without verdict, but it's supposed to be expungable. Yes, ma'am. Okay.
I have a question.
Yes, sir.
I actually went to one of the CREP, CLE, the training here. That was a couple years ago.
Really? Oh, great. Wow.
And one of the things they said was that in Philly, sometimes the DA would take the position that in a situation where you might be eligible for redaction, that they will oppose it because they're saying, look, you negotiated a plea. So we could have convicted you on other counts. And I'm just wondering, are they still taking that position now? Are the DAs opposing it?
We haven't had, honestly, we've had one gentleman whose petition was denied, and I think it was because we filed too early. And the judge said, just come back and file it in 2016. So they may still try to make that same argument, but it's not an argument for a lot of our clients that have been winning arguments.